special exceptions for Miss Lyra's original answer requesting attorney fees.
Okay.
Parties are in agreement that the child lives with the father currently. Parties are in agreement that the child has government medical. Parties are in agreement that the mother has no other children. Gross monthly wages are $3,900. Parties are in agreement for the father not to receive any retroactive child support. Parties are in agreement for a geographic restriction to the Dallas and contiguous counties. At this time, I am going to take testimony. Mr. Abrego, can you please state your full name?
Yes, ma'am. My first name is Christopher. Last name is Abrego, Abrego.
Sir, can you please state the name of the child of this matter?
Emiliana Vidane Abrego, ma'am.
And her full name? I'm sorry, her age?
14.
Sir, did you hear the pronouncements that I made?
Her age?
No, did you hear the things that I stated?
Oh, yes, ma'am. Yes. I'm sorry. Yes, ma'am.
Are those parts still your agreement?
This case opens with a familiar frustration, a delayed child support modification that's been stuck for nearly a year. The father's attorney explains that both parties agreed by email to reduce support from $2,300 to $2,000 per month. But bureaucracy and state assistance complications stalled the process. The father kept paying the higher amount, waiting for the court to make it official. It's a simple motion, but a long, unnecessary delay turned it into a legal headache.
Yes, I mean...
Just those parts, sir.
That's fine.
Okay. Do you believe they're in the best interest of your daughter?
Yeah. That's exactly the reason why I'm doing all this.
Okay. And are you asking the court to accept those parts?
Yes, ma'am. The ones that I guess it's coming to agreement. Is that what you're talking about?
The parts that I read as an agreement are asking the court to accept those parts.
Yes, ma'am.
Okay. Sir, when your daughter was born, did you sign an acknowledgement of paternity?
Yes, ma'am, I did.
And you signed and dated this document?
Yes, ma'am, I did.
Okay. Your Honor, may I share my screen?
Sure.
Can you see this acknowledgement of paternity, Mr. Abrego?
Yes, ma'am, I do see it.
You see your name here?
Yes, ma'am.
And you see Emiliana's name here?
Yes, ma'am, I do.
And you see Nancy's name here?
Yes, ma'am.
And here, this is your signature and date?
Correct, ma'am.
And Nancy's signature?
Correct.
Your Honor, this would like to offer the acknowledgement of paternity as it states Exhibit 1.
States of 1 is admitted.
Okay. Sir, are you aware that the mother is now requesting a DNA test?
Things get complicated when the mother's attorney withdraws right before the hearing. A substitute lawyer, appearing as a professional courtesy, asks for a delay, but the judge shuts that down fast. This has been pending for over a year. Enough is enough. The judge points out that the email exchange between both parties is a valid agreement under court rules. The courtroom mood shifts. What was once a discussion is now a decision in motion, with the judge clearly tired of procedural games.
Yes, ma'am, I do. Yes, I am aware of that now.
Thank you. And you understand that she's stating that she believes that your Emiliana is not your child.
I do understand that now.
Okay. All right. You are requesting to be, if the case goes forward, you are requesting to be named joint managing conservators with Miss Lyra. Is that correct?
Yes, ma'am. That means sharing custody, correct?
Sharing conservatorship, yes.
Yes, ma'am. I'm fine. I want that.
And you are in agreement for her to have a state standard visitation. Is that
Yes,
correct?
ma'am. I want her to be available to her mother as much as possible.
Okay. The state is recommending child support to be set at $610 starting December 1st, 2024. Are you in agreement with that amount?
Yes, ma'am. As long as y'all decide that, that's what I agree with.
And as your child is under receiving government medical, the state is requesting for cash medical to be set at $250 a month starting December 1st, 2024. Are you in agreement with that?
Yes, ma'am.
Sir, you stated, has there been family violence between you and Miss Lyra in the last 2 years?
No, ma'am. She's made allegations of it, but they've came and checked everything out, and it was all false.
Are you requesting a non-disclosure?
What is a non-disclosure, ma'am?
The judge makes it clear he's done waiting. He declares the email agreement binding and orders it entered immediately. If the mother wants to object, she need to explain through her new attorney why court rules shouldn't apply. The father's attorney reiterates, his client's been paying faithfully, even overpaying. The judge appreciates the fairness and transparency, clearly favoring the side that stayed consistent. After a year of stalled progress, the system finally moves forward.
Do you have any safety concerns with her having your phone number?
No, ma'am.
Do you have any safety concerns with your address being in today's order?
No, ma'am.
Are you in agreement with court costs being billed to her today?
That's fine.
Is there anything else you think the court should know about your case?
Ever since she kicked me out and my daughter's been with me, a lot of these allegations started coming up with the sexual allegations and the violence and all that, and everything's been. I've let all the authorities check everything out, and everything's been checked out thoroughly. But yeah, that's how all that's beginning. Other than that, that's about it, man.
Okay, I pass the witness. Miss Lyra, can you please state your full name for the record?
Nancy,
Miss Lyra, the beginning portions I read as an agreement, are those portions still your agreement?
you said no retroactive, regards to the father, income, regards to the father, as far as like retrieving any past due amounts that may be applicable.
No retroactive support of you owe to him.
Okay. I'm not sure if I'm able to add, the years that he was not provided for the
So
family.
you want to pay him retroactive child support? Is that what you're saying?
No, not myself, as far as himself paying it back to me.
So ma'am, you're not in agreement with the earlier portions that I read?
Because I don't have an attorney present, I'm not quite understanding the terms of this. So that's
Okay.
why it is going to be redundant with me a little bit until I understand what it fully means.
That's fine.
And that, because it you know what I mean? It's just the eloquency of the words are just there.
Okay, ma'am. I will start over, okay?
Then the conversation takes a personal turn. The father's lawyer highlights that the mother, a single mom raising the child, never had an issue with the $2,000 amount. She confirms this herself, saying she's always been on board. But there's a twist. The father's been overpaying by $300 a month. So the order temporarily reduces support until the balance evens out. The judge notes this keeps things fair for both sides. It's a moment where logic finally overrides emotion.
Ma'am, is your child covered under the government plan?
Yes.
Ma'am, is it true that you don't have any other minor children?
Correct.
Ma'am, is your gross monthly wages $3,900?
Approximate. Correct.
Okay. Ma'am, are you in agreement not to pay the father retroactive child support for the periods that the child has lived with the father?
Correct.
Okay. Are you in agreement to a geographic restriction to the Dallas and contiguous counties? That is the 40 miles outside of Dallas.
Like me being restricted to stay away?
Not stay away from your child, ma'am. Are you in agreement for the father who the child lives with not to be able to move with the child outside of the Dallas and contiguous counties without notifying the court and you for permission first?
Correct.
Are you in agreement with court costs being billed to you today?
No.
Okay. And, okay. Ma'am, are you requesting a DNA test?
Yes.
Okay. And you saw the acknowledgement of paternity that you signed 14 years ago?
No, yeah.
Ma'am, did you see the acknowledgement of paternity that I showed earlier?
I saw the copy.
Okay. And how old is your daughter?
She's 14.
Okay. And have you had an opportunity to do a DNA test before now?
The mother explains her side. She's frustrated by how long her previous lawyer, Connie, took to finalize things. She says she kept following up, only to get silence. When the new motion arrived, she was confused. She thought everyone had already agreed. The judge agrees that this case was unnecessarily delayed by poor communication. Both parties finally align, and the court is ready to lock in the $2,000 monthly support. It's a simple agreement that should have been done months ago.